Michael Catone of the Nashville Bar, appearing on behalf of Tinsley Properties LLC and Tinsley Sand and Gravel LLC. I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
This is a case about what happens when counties use procedural shortcuts. There are two county resolutions at issue in this case. They purport to regulate the location of quarries within Grundy County. Now, under Tennessee law, the county could have regulated quarrying through the use of the statutory zoning procedure under Title 13. It can still do that if it wants to. In fact, the zoning statutes specifically contemplate the regulation of sand quarries, but the county didn't do that. The county instead tried to rely on its general police powers under 5-1-118C. Now, the resolutions are void and invalid for two separate and independent reasons. The first is that 118C specifically provides that a county can't use its police powers to regulate activities, businesses, or uses of property that are subject to regulation under Tennessee's Air Quality Act or Water Quality Act. Now, quarrying is subject to regulation under both. Either one would be sufficient, but it's subject to regulation under both.
Wouldn't the regulation have to purport to be related to air quality and water control?
Your Honor, that's nowhere present in 118C. I think the text of 118C is very clear that a county is not allowed to use its police powers to regulate any activity, business, or use of property that is subject to regulation pursuant to the Air Quality Act or the Water Quality Act.
So the county, if that property was subject to that statute, then the county has nothing they can do. It's hands off.
No, that's not correct, Your Honor. The county can, as I mentioned, regulate quarrying through the use of its zoning procedure. That is an option that is completely available to the county. It's still available to the county, and there are additional procedural safeguards that are present for zoning, but those were not followed here.
And in this case, is it fair to say the county insists that this is not a zoning ordinance?
I don't presume to tell you what the county is arguing. I think the county has said both that it thinks that the substantial effects test doesn't apply, and also, which I will discuss a little bit further, but it has also said that it's allowed to enact zoning through 118C, but that's inconsistent with both the text of the statute and with Tennessee Supreme Court precedent. So in my mind, I think the county has all but conceded that this is a zoning type regulation. Addressing this air quality and water quality control issue, 118C says that a county can, as I mentioned, that a county can exercise the same police powers as municipalities, except with respect to activities, businesses, and uses of property that are subject to regulation under air quality and water quality. So the question is quarrying subject to regulation under air quality or the Water Quality Act? And the answer is yes to both. It's not legitimately in dispute in this case that to operate in Tennessee, quarries are required to obtain air quality and water quality permits. It's a requirement. The record is clear that quarries meet the standards under the Water Quality Act to be required to obtain permits. The record's also clear that TDEC has specifically provided guidance that mines like quarries are required to obtain water quality permits. And the record's also clear that Tinsley and other quarry operators have applied for and obtained water quality permits from TDEC. And the permit that
were they obtained before Tiffany commenced operations?
Your Honor, the water quality permit in this case was obtained before.
But the air quality was not.
The air quality application was submitted later. Now, the trial court relied on that fact. Frankly, I don't think it's relevant. Either quarrying is subject to regulation pursuant to these acts and permits are required, or it's not. Also, for reasons that are outside the record, I believe that the permit application was timely in this instance. Regardless, if it wasn't timely, that's a matter for TDEC to take up. The fact that they have to obtain an air quality permit, which is clear in the record, clear from TDEC's own administrative proceedings. We have cited a minimum of 2 administrative proceedings, recent ones from 2021 and 2019, that show that TDEC has instituted administrative proceedings and imposed civil penalties on quarries that have failed to obtain air quality permits. I think again, there's no real dispute that quarries are required to get air quality and water quality permits to operate in Tennessee. And permitting is a form of regulation. That's the whole point. That's the whole point of permitting.
So under your interpretation, which which you're putting out here, the county has no right to be concerned under its police powers that there is an operation out there that is using explosive materials, blowing holes in the ground to quarry, whatever, within 5,000 feet of a school. That's not a concern?
Your Honor,
not something the police powers can address?
I'm certainly not saying it's a concern. It is something that the police powers cannot address. There is a statutory procedure to address those issues, and it's zoning. There are also any other number of regulations that could be put in place that don't prohibit quarrying or define areas where quarrying can and can't occur that could ameliorate some of those effects.
Okay, Grundy County doesn't do zoning at all? Is that what?
Your Honor, it is not currently enacted any
zoning regulations. No. So if Grundy County wanted to regulate this particular area under its zoning authority, does it have to have a comprehensive zoning ordinance that covers the whole county?
It would need to follow all of the statutory zoning procedures. That is one of them. It would need to enact a zoning plan.
So zoning is all or nothing. Is what you're saying.
Your Honor, there are a lot of different ways that zoning can take form, right? Zoning works differently in different parts of the states in terms of what's zoned and what isn't zoned.
Grundy County would have its authority to decide how each part was zoned. But what I'm asking is, can you do a zoning for one particular area, say within 10,000 feet of a quarry, or are you required to put zoning down all over the county in order to do that?
Your Honor, I'm not sure I have an answer for you on that.
Fine.
I would.
It's a little out of, if not left center field.
I'm certainly not. I certainly don't know all of the ins and outs of zoning law. Every speck and jot in Tennessee. In all of the zoning cases I have dealt with, what has been demonstrated to me is that municipalities and counties have a great deal of flexibility in how they decide to zone things.
Thank you.
On the substantial effects issue, this is the second issue. The resolutions are void and invalid under the substantial effects test adopted by the Tennessee Supreme Court in Cherokee Country Club, and as further explained in the SNPCO decision. I think the Tennessee Supreme Court adopted this substantial effects test to address the exact situation presented by this case, which is where a local government adopts what looks almost exactly like a zoning ordinance without following zoning procedures, and instead simply tries to rely on its police powers. The Tennessee Supreme Court could not have been more clear on that. It's not allowed.
Doesn't a county or any other municipality have an obligation to the citizens to make sure that certain industries or certain groups do not, that's dealing with a certain amount of traffic is within a certain area, noise within a certain area, away from people's home and schools and stuff like that? Isn't there an obligation that they would have to do that?
Your Honor, I don't know if there's an obligation. It's certainly something that counties could address through the use of noise ordinance, traffic regulations, things that are not zoning type ordinances that ban quarrying in particular areas of the county. I think the Tennessee Supreme Court is very clear that if what a county is doing is enacting a zoning regulation, it has to follow zoning procedures and cannot rely on its police powers. There are two prongs to the substantial effects test. I think the argument on the substantial effects test really boils down to one point. Both the county and the trial court found, relying on some peculiar language from SNPCO, that if a county does not adopt a comprehensive zoning plan, then the substantial effects test just doesn't apply at all. That's simply incorrect. That's an issue of first impression in Tennessee. Importantly, SNPCO did not deal with that issue at all. That was not an issue that was before the court. There is authority on that topic. The Sandy Mush decision from North Carolina that we cited in our briefing specifically rejected that argument. We're not aware of any contrary authority. The county certainly hasn't cited anything. If the court reaches this substantial effects issue, it's going to have to make sense of that first prong and how to apply it when a county hasn't adopted a comprehensive zoning plan. I think Sandy Mush, and language that was quoted by the Tennessee Supreme Court, really put it best. The purpose of the test is to figure out whether the effect of the ordinance is to make unzoned areas of a county subject to zoning regulations. That's exactly what the resolutions do here. They're zoning without following zoning procedures. I see I'm running out of time. For all these reasons and the reasons that we've stated in our briefing, we ask that the court reverse and remand with instructions to enter summary judgment in Tinsley's favor.
All right, thank you, Mr. Catone. We'll hear from you again on rebuttal. Good morning.
Good morning, Your Honors. Pleased to be here. My name is Bill Reeder. I'm from the Coffee County Bar, and I'm representing Grundy County. And by the way, I'm a native of Grundy County, so I've got a peculiar interest in this case.
Does Grundy County have a zoning
No, sir.
plan?
And that's a part I want to address right now. But what they didn't recite is we did cite authority. That the SNPCO case specifically does not state what they says. They came back after the Cherokee Country Club case. And in that case, they said a permanent ordinance that prohibited issuance of demolition permits on properties that were to be considered to be included in a historical zone could not be granted until the application process provided in the zoning ordinance or the zoning code had been complied with. Well, and they did not follow the procedures for amending the zoning ordinance. So essentially there, what the court says is when you have a zoning ordinance and when you're regulating something that's totally and closely related to that and dependent upon it, you have to follow the zoning process. SNPCO came back and said, and what they did, so we want to clarify this substantial effects test. It's not just whether it's a two-prong test. The first part is, and I'm almost quoting verbatim here, is whether you got to review the ordinance in question, in this case would be our resolution, with the comprehensive zoning plan. And if that resolution is related to and dependent upon that zoning plan or zoning ordinance, you have to follow it. Now then, this statute does not require that. The statute under the County Powers Act specifically provides the way that those resolutions are to be enacted. And that is with first you got to adopt by 2/3 a resolution that allows you to adopt the County Powers Act, which there's no dispute that Grundy County did. Then to get to those powers, the county, by a 2/3 vote of the legislative body, has to adopt the resolution that's included there. That's precisely what Grundy County did in this case. No dispute. And you can see that what they did, they gave a choice to counties, especially small counties, that you can either exercise these powers that limit business areas where businesses can be located. And that's precisely what this Grundy County did. Second, or you can adopt a zoning ordinance. Now,
So your argument is that under the Powers Act, the county has the authority to regulate where certain businesses locate.
That County Powers Act gives them the power to prescribe limits within which those businesses that are liable to be nuisances may be operated. Yes, sir.
But at the same time, you argue this is not a zoning
It's
ordinance.
not. And I show that by the history.
Clear that for me.
When you look at the legislative history, and there's been several amendments to this. The statute was initially adopted in 1995. There was no provision in there for them to adopt these police powers. Then it was, I think, amended in 2000, and it lets counties with certain populations do it. Then amended in 2001 to change the populations. And this is the key one. In 2002, it was amended to allow any county without a zoning ordinance to adopt these police powers. Then in 2002, it came back and said it has expanded that to all. But when they specifically, in 2002, made it applicable only to counties that did not have a zoning ordinance, they were granting them that option that you can make these regulations and you can adopt these regulations with a 2/3 vote. Now, I think the 2/3 vote is significant to distinguish this type of police power regulation from a zoning ordinance, because this prescribes, under the zoning ordinance, you have to go through certain procedures, but the ordinance can be adopted by a simple majority. To distinguish that, under our statute, the legislature imposed the requirement for enactment by a supermajority of 2/3. The other thing, when you just look at the precise wording of the statute with respect to whether or not it's a zoning ordinance or has to follow the zoning ordinance procedure, is that within that TCA 511-118, it states that statutory and case law relating to non-conforming uses and variances regarding zoning apply in the enforcement of this particular type of statute. When they limited what amounted to zoning there with by saying that it only applied to the variances and non-conforming uses. It did not mention enactment. And, Your Honor, to accept their provision, this statute would have been totally useless if they were going to then require a county to adopt the resolution by going through the procedure of a zoning ordinance, because they already had that power under zoning. All counties had that power if they wanted to enact a zoning, comprehensive zoning plan. But when they came along this was primarily for small counties like Grundy County that did not have a comprehensive zoning plan. And I think when you follow the statute, precise language of the statute, the legislative history of that statute, and the SNPCO case, we're at this position. And I would also point out before I get to that, the Attorney General's opinions. There's been 2 Attorney General's opinions that we've cited in our brief that specifically state that this gives a county an alternative to do some regulation other than adopting a zoning ordinance. And those have been repeated. Now, I know that Attorney General's opinion is not binding authority, but neither is an out-of-state opinion. But Attorney General opinions are, under this court is held, are entitled to considerable difference, especially in matters involving statutory construction. That's exactly what we have here. And by the way, that other case was not followed in SNPCO, the Sandy Brush case. It was a mere footnote that said that the Cherokee, that the court in the Cherokee case relied on that under the peculiar facts of that case. Now then, so I think where we are left after SNPCO is this. A county has an option of how they want to proceed. They can proceed under the County Powers Act, or they can proceed under zoning. If you proceed under zoning and you want to enact a regulation that is closely related to your zoning act, and dependent upon that, you have to follow the procedure to amend. If you don't, you follow the procedure with a 2/3 vote. And that's exactly what we've done in this case. Now, I want to hit on just a little bit the exceptions they're trying to rely on with regard to the Air Quality Act. First of all, I do think it was significant, and the court noted it, that Tinsley didn't even apply for this act. They didn't even apply for a water quality permit till we had filed our first motion for summary judgment. After that they filed for it. Second of all, when you look at the permit, and it is in the record, their application, and by the way, there is no permit in the record to operate a quarry. But if you look at their application, it was not to operate a quarry. It was for permission to construct it. That was all. And they gave a beginning and an ending date for that in that application. The ending date was in October of 2022. That permit does not, even if they had it, does not give them a permit to operate a quarry. Second of all, the publication that we got, it's in volume 5, page 811 of the record, from the Air Quality Board, and it specifically talks about, and it says, construction permits issued by TDPAC do not grant any authority to operate, construct, or maintain any installation violation of the law. Local. Well, this one would, because it didn't violate a regulation, but I think one of the key things in there is the fact that they talk about not permits to operate, but construction permits, which will expire after it's done. The Air Quality Act does not in no way, shape, form, or fashion attempt to regulate the integral activities of a quarry. The blasting, the drilling. In the record, the affidavits from the residents there talked about the blasting, how it shook the ground underneath their residence, knocked stuff off their shelves. Felt like the ground was coming underneath them. Sounded like a large sonic boom had landed on their house. Then they discussed the effects of the drilling. And I think there is also included in the record a CD that records the effect of that blasting. And you can see where it just shook the post right there by the gentleman's house. And then they talked about the drilling. Not only, it wasn't to the extent of the blasting, but it was very loud, where they couldn't hear them, where they could hear it while they were in their house and talking with each other and disturbed them. And then the traffic, the heavy traffic of those trucks on a small gravel road. None of that is regulated by either the Water Quality Act or the Air Quality Act, top, side, or bottom. And
Well, you're touching on the issue already, but let me follow up on a question Judge McClarty asked, and that was Tiffany was saying the county was prohibited from regulating anything related to the scope of the Water Quality Act and the Air Quality Act.
Your Honor,
And what is your position on that?
I think if the county was trying to regulate activities that were in fact regulated by those acts, that we would be running afoul. In other words, if we tried to set more restrictive parameters on the effluents for the water, or if we tried to enact some kind of regulation that would affect the Air Quality Acts, then I think we would be running afoul. I think the purpose of that was, if you look at the purpose of both of the Air Quality Acts and the Water Quality Acts, the overlying purpose is to protect the citizens of this state, to give us clean water and clean air. And they want to, but that provision, they want to ensure a uniform enforcement of that. In this case, there's no overlap, and I think that what Tinsley's wanting us to do is to take those provisions of the Air Quality Act, which is designed to protect the citizens, and let it be a shield to them so that they can engage in blasting, drilling, whatever they want to, right next to an individual's home and say, well, the water effluent is controlled by the NPDES permit. And on that, I see I'm about to run out of time. The NPDES permit does not give them permission. It's not a permit to operate a quarry. It's simply to discharge wastewater. In other words, if they got to meet all other regulations to operate the quarry before that comes into play. And my time is up, and thank you for your...
All right, thank you, Mr. Reeder. We'll now hear rebuttal from Mr. Catone.
Thank you, Your Honor. I want to start out by saying, let's look to the specific language of Section 118C2. It says specifically that a county cannot use its police powers to regulate any activity, business, or use of property that is subject to regulation under the Air Quality or the Water Quality Control Acts. Now, the record is clear that, there's been a lot of, the county has relied on, saying, well, we're trying...
Does activity mean quarry, or is it more specific, like blasting or traffic?
Your Honor, I think activity would include quarrying, but business certainly includes quarrying. Quarrying is a business that is subject to regulation under the Air Quality and Water Quality Control Acts.
But not every aspect of quarrying, just what they put in the air and what they put in the water, right?
Your Honor, I do not think so. I think that to operate a quarry, you are necessarily emitting particulate matter into the air, and to do that, to operate a quarry, you have to get a permit.
So if one has a quarry and one obeys the air and water requirements, the county is absolutely handcuffed about the traffic that the quarry creates on the county roads and the noise that it might create? Or?
No, Your Honor, I think the county has every ability to enact traffic regulations and noise regulations pursuant to the County Powers Act. What they don't have the ability to do is do zoning, which is what they have done here. They have established areas where quarrying is not permitted. There are any number of things that a county could do to address those issues, but the county hasn't regulated blasting, it hasn't regulated traffic, it has regulated quarrying, and it has created areas where quarrying is not permitted. And that runs directly afoul of Section 118C2. Now, I want to take a minute to talk about the permitting a little bit. I think there was a mistake that was made about the timing of this. The water quality permit was in place before the filing of this lawsuit. The water quality permit was in place before the filing of this lawsuit. The air quality permit, yes, there's a construction permit. It's a two-step permitting process. You have to get a construction permit before you get an operational permit. I think we've seen from the regulatory enforcement actions that are in the record that if you don't get both, that TDEC is going to come after you if you are a quarry. I see I'm out of time.
All right. Thank you. Thank you both for your argument. We'll take your case under advisement.